Akua Reindorf is a barrister at Cloisters Chambers, specialising in employment discrimination and human rights law. She's instructed in cases involving polarising and contested identity and equality issues, including appearing for LGB Alliance in the challenge to their charitable status brought by Mermaids. Representing James Esses in his claim for discrimination. And acting for Julie Bindel in her discrimination complaints against Nottingham City Council. In 2021, she conducted the Reindorf Review for the University of Essex, which was a landmark contribution. Akua is a commissioner of the Equality and Human Rights Commission and a fee-paid employment judge, and she's Chambers and Partners Employment Junior of the Year and is featured in the Lawyers Hot 100 for 2022 and will be and she is to be appointed King's Counsel in 2023.
When I agreed to speak at this conference, they didn't tell me I was going to be doing the opening plenary. Kept that bit quiet, so I'm extremely honoured, but a bit overwhelmed, although I'm glad to see that at least some people have been kept back, probably by the train strike, so it's not quite as many people as I thought. But at least also I'll get it over with so that I can listen to some of the amazing women who are speaking later on in this conference. I'm just going to start with a couple of items of personal housekeeping. The first is I'm speaking entirely on my own account today and not on behalf of any organisation or in a professional capacity. So I'll be talking a bit about the law later on. Please don't rely on it and then sue me for professional negligence. Also, secondly, please forgive me if my voice starts dropping and getting croaky, because it does happen when I drone on. It's a neurological thing. Right, that's the housekeeping. Excuse me. So this Women's Liberation Conference is really nostalgic for me, because I'm of a generation that grew up with Women's Lib. And as a teenager in the 1980s, I used to go around Women's Lib protests and marches and so on with my mum. And in those second wave days, am I too far? Oh, there we are, crikey. Is that better? You can all hear me now. I can hear myself, which is odd because I don't really like my voice. Okay. In those second wave days, feminism and women's liberation were woven into the fabric of left-wing politics. And we used to go to academic conferences called things like the Moving Left Show, and we made the obligatory pilgrimage to Greenham Common to visit the women there protesting at the peace camp. And we'd go to Glastonbury in the days when it was a CND festival, which it isn't anymore at all. But of course, outside of those left-wing circles, the women's liberation movement and feminists in general were ceaselessly pilloried and mocked in the media and in wider society. But we fought on, and we shifted things, and we reached a place where Theresa May felt able to present herself in a "this is what a feminist looks like" t-shirt. So now everybody agrees, at least in the abstract, that feminism is a good thing. And another thing that I thought everybody agreed was a good thing is freedom of speech. I thought everybody understood that it's a human right and that we must allow voices to be raised in protest, and that debate and discussion is how good and constructive ideas are raised up, refined and progressed, and that debate and discussion is how bad and dangerous ideas are exposed to the disinfectant of sunlight. And like feminism, free speech, the principle that freedom of speech is essential in a democratic society, is something that I understood to be in the DNA of the left. In my memory, it was always the right that was moralistic and censorious. It was the right that had Mary Whitehouse and Section 28 and back to basics. And freedom of expression was championed by the great legal and political institutions of the left. Amnesty International, Liberty, in the United States, the ACLU. Those institutions were all founded to advance freedom of conscience and freedom of expression for the oppressed, the marginalised, and the disenfranchised. And because they understood that human rights are for everyone, and freedom of speech is a two-sided coin, they also fought for the free speech rights of really extreme voices on the other side of the political divide. The ACLU, in particular, is famous for representing and defending the free speech rights of some really quite obnoxious people. But in a bizarre reversal, over the last 10 years or so, freedom of speech seems to have been hijacked by the right and abandoned by some people on the left. And nowadays, talking about freedom of speech is seen by a lot of people as a right-wing dog whistle. And that's nowhere more true than in universities, which is precisely where freedom of expression is supposed to reach its most elevated plane amongst our human rights and fundamental freedoms. And like a lot of people, I think I was only dimly aware over the last 10 years or so that this was happening. And the other thing I was only dimly aware of was that there was a storm brewing over sex and gender at around the same time. It was probably around 2017 that I naively dipped into Twitter to see what all the fuss was about on that issue. And what I saw was truly shocking to me. People on the left, mainly men, were attacking what I thought of and what seemed to me to be, without meaning to cause offence, bog standard left-wing feminism, over which I thought we had reached a degree of consensus some considerable time previously. They were telling middle-aged feminists who didn't appear to be acting in any sort of bad faith that their feminism was bigotry and hate and fascism, telling them that their words were violence and that none of this was up for debate. And they were saying these things with such aggression and vitriol and certainty, as though their really quite counterintuitive views and ideas were some sort of received wisdom, and as though they were talking to actual fascists. It didn't reflect my experience of talking across the ideological divide at all, still less of talking within left-wing or progressive circles. I mean, of course, oh, someone's got a baby. I miss babies. I shall have to come and find you later. Of course, the past wasn't a utopia for women's freedom of speech. Within the left, even, women's voices have often been drowned out and marginalised. But what I don't remember from the past is feminists, or my past, is feminists being routinely, actively told to shut up, or being sacked from their jobs because of thinking the wrong things, or being frozen out of their careers, or being deplatformed, or being kicked out of political parties, or being told by the very organisations that had been founded to protect freedom of speech and who had gone to court to argue for the free speech rights of the Ku Klux Klan that their feminism was beyond the pale and unspeakable. So, of course, having looked at all of this on Twitter, I thought I don't want anything to do with this. I shut the computer down and didn't look at it again until I was dragged back into it a couple of years later, purely by chance. And long story short, here I am now. Anyway, I'm going to talk for the rest of my time about how the law can be used to uphold the free speech rights of feminists who want to bring their whole self to work. I'm going to talk in particular about the higher education workplace, partly because it's the subject matter of this conference, but also partly because I think that universities are the eye of the no debate storm, and that because of that, where university employers lead, others will follow. Now, we know that change is already happening. We've seen legal successes for Maya Forstater, who I'm hoping is here. Alison Bailey. Are you here, Alison? She's here. I don't know if she's here. Sonia Appleby. And others. And there are more cases in the pipeline. I'm not going to talk about any of the cases I'm involved in, but there are others. What's interesting about these cases from a legal point of view? Well, there are many interesting things, but one of the interesting things is how many different ways that there are to argue the cases. The law has many roads. It's a complex landscape, and there's a panel discussing this later on this morning, which I'm really looking forward to taking part in, and I'm sure at that panel discussion there'll be some discussion of the various legal possibilities. But what I'm going to talk about now is some of the things that we know for a fact at this point. Thanks to Maya, we now know for a fact that holding gender-critical beliefs is protected by Section 10 of the Equality Act. And the same applies to any other feminist ideas, as long as they're sufficiently coherent and respectable. You can't be sacked just because you're gender critical. You can't be subjected to a detriment in your workplace or your place of study or when you're using a service because you have feminist ideas. Your mere presence cannot lawfully be treated as a contamination of your university campus, despite that having been suggested in a certain academic paper. We also know for a fact that the right to hold a belief is an absolute right. Other than for beliefs which are truly heinous, like Holocaust denial, there are no exceptions. And the reason it's an absolute right under the Equality Act is because Section 10 of the Equality Act has to be read and applied in accordance with Article 9 of the European Convention on Human Rights. And that's the article that protects freedom of thought, conscience, and religion. And unlike some other convention rights, it's unqualified. Another thing that we know for a fact is that expressing gender-critical beliefs or other feminist views is also protected by the Equality Act. Because Section 10 of the Equality Act has to also be read in conformity with Article 10 of the Convention, which is the freedom of speech article. And a really important point is that this is how we know that freedom of speech is part of equality law. It's not just in the elevated plane of human rights law, which you can, it's part of the Equality Act, it's in the Equality Act, which you can enforce in a tribunal without a lawyer if you must, but I won't recommend that. So you have a right under the Equality Act not only to hold your beliefs, but also to express them. And that is as it should be, because there's a misapprehension that freedom of speech is a threat to equality, diversity, and inclusion. But in reality, it's nonsense that inclusion can only be achieved by stopping people from expressing themselves. There's no equality or inclusion where people are silenced. There's no diversity without diversity of thought. And that's why the great social justice institutions, Amnesty, Liberty, the ACLU, and so on, all started out fighting for freedom of conscience and expression, because that underpins all the other rights and freedoms. So employers and educators really need to start getting their heads around the fact that they need to integrate freedom of expression and freedom of conscience into their EDI schemes rather than treating it as the enemy at the door. So, but having said that, expressing your beliefs is not an absolute right. It is qualified and it can be restricted. So, for example, it can be restricted if what you're saying amounts to unlawful harassment because of somebody else's protected characteristic or related to somebody else's protected characteristic. But nothing is automatically harassment. And nothing is harassment just because the victim feels like it violates their dignity. If what you said wasn't intentional, then it has to be reasonable for the purported victim to have felt that way about it. And that's an objective test. It will always depend on the circumstances. Another thing that we know for a fact is that if you're an academic, you have a gold-plated right to freedom of speech in your work. Academic speech has the utmost protection under Article 10. And on top of that, you have academic freedom, which is about to be strengthened in new legislation. And if your employer is trying to decide whether something you said was unlawful harassment, they have to take into account the fact that freedom of speech has that gold-plated protection. And they have to take into account the fact that you've got a right to academic freedom. And what that means in reality is that the law recognises that in a university where the idea is the production of knowledge and truth, people can expect to encounter and be confronted by ideas that they might experience as an affront to their own beliefs about their personal identity. The aim of academic freedom is the production of knowledge and truth. And because you can't make an omelette without breaking eggs, you can't produce knowledge or truth without testing and questioning almost every idea, even the upsetting ones. But all of that is known by academics. You'd be really hard-pressed to find an academic who would say they don't believe in freedom of speech in universities or academic freedom. What they tend to disagree about is whether there's currently a crisis in higher education as regards freedom of speech. In my experience, the ones that are willing to talk about it at all are generally of the view that there isn't a crisis. They often say that it's a culture war issue being confected by the right wing. I mean, they can see what happened to Kathleen Stock, And they can see what happened to Selina Todd in Cambridge 3 years ago. They just think those are one-off incidents. And what they don't necessarily see is the chilling effect that those high-profile cases can have on other people. And to be fair, it can be difficult to see out from inside a bubble. For every Kathleen Stock and Selina Todd, there are others who are fearful that if they put their head above the parapet, they will be ostracised and cast out. In my view, it's not everywhere and it's not everyone, but it is happening. So the question isn't whether there's a problem. The question is, what are universities prepared to do about it? The good news is that things are changing. In my experience, and this probably won't be a popular opinion with some of you who may be at loggerheads with your institutions, but in my experience, university leaders very clearly recognise that there is an issue to be addressed. Their minds have been focused somewhat by what happened to Kathleen Stock, by Maya's case, and by the forthcoming new legislation on academic freedom and freedom of speech. But generally speaking, they do believe, even apart from those factors, that freedom of speech in universities and academic freedom are important. Academic freedom is an article of faith amongst most people in universities, as far as I've encountered. And generally speaking, they want to get it right, not least because of the draining, intractable nature of the disputes that arise in this space, that take up an inordinate amount of time and resource. But I think they've been held back by four things. Firstly, people working in universities are just as bemused by the toxicity of this conflict as the vast majority of people in the general population are. Secondly, they've been given erroneous guidance and advice by lobby groups. Thirdly, they genuinely don't want to be horrible to people. And fourthly, the law is really hard in this area. It's really complicated. All I've touched on so far is the right to complain about direct discrimination because of philosophical belief. But there are new and exciting ways of arguing these cases being dreamt up by clever lawyers like Peter Daly every day. Well done, Peter. Just in employment law, there's indirect sex discrimination, victimisation, whistleblowing detriment, automatically unfair dismissal for asserting a statutory right, and I could go on. And when the new Act comes into force, the Freedom of Speech Act for universities comes into force, it will have some kind of enforcement mechanism, and even if that's underwhelming, it will feed into the legal context. The truth is that the law will always be a step behind what's happening on the ground, but luckily in this area it is starting to catch up. It's a work in progress, but a new landscape is hoving into view. I'm going to wrap up, but before I do, I just want to ask you how many of you, well, you don't need to answer, it's a rhetorical question, but how many of you would have come to this conference or a conference like this 3 years ago before Maya won her appeal? It's not everybody, and I didn't think it would be everybody. How many, there are those amongst us, and I probably count myself amongst them, who would not have risked their colleagues, their employers, their friends, seeing clips of them on social media walking past the pots and pans people outside. And I suspect that it's partly because of the legal advancements made in relation to women's rights to speak about their feminism, that some of us, in Maya's words, are braver today than we were yesterday. And the final thing that I want to say that I know for a fact is that no debate is over.